So what are some reasons why the U.S. Patent and Trademark Office might reject a application for protection of a trademark? Well, we talked about in a previous video the requirements that a trademark have certain distinctiveness or secondary meaning, and we gave the scale that it could be fanciful, arbitrary, suggestive, or descriptive, and achieve that distinctiveness or secondary meaning as long as it doesn't reach the point of becoming generic. Okay, but common reasons why the Patent and Trademark Office would reject the application beyond it simply being generic is the mark is too similar to another mark that's already been registered, that somebody else uses a mark so similar to represent their business that granting you rights in that trademark would cause confusion between your mark and that mark that's already registered. So basically someone got there first. The mark could have certain prohibited symbols or reserved names or designs by other people. If you include somebody else's trademark image or design or copyrighted words or something like that within your trademark, then again, that could be infringement on their intellectual property rights, and it could be rejected for that reason. Another reason would be, say the mark merely is descriptive, but you can't demonstrate sufficient secondary use or meaning to say sufficient use to say that it is achieved secondary meaning, that people now equate this description of your product or service that you're trying to trademark as being associated with your trademark. So if it's too descriptive, again, without achieving distinctiveness through secondary meaning, the Trademark Office may reject it. And lastly, if it was protectable at some point in time, but has become so used in a generic sense, such as I'm going to Google this to look up something on the internet. If Google ever allows that word to become used synonymously with look something up to the exclusion of every other term, then it could become generic. Okay. So that would just be an example. Xerox also faced that threat at one point in time because individuals thought Xeroxing was the equivalent of photocopying it. Okay. So in that sense, a word that was once protectable could become generic. And in that sense, if it's generic, again, the Patent and Trademark Office will reject it.